I am extremely happy today to see all of you, the respected members of the bar on the dais, City Civil and Sessions Courts Bar Association, who is already having a great repute amongst the judges, who has organized this such a wonderful lecture series for we all. Friends, the object of this particular lecture series probably is to make more powerful and more effective bar in our City Civil and Sessions Court. In fact, I would suggest the members of bar that such type of activities, such type of study circle groups should be formed, and continuous exchange of thought, continuous exchange of legal knowledge should be made as a habit for we lawyers. Friends, coming to the topic today, Commercial Courts Act, Practice and Procedure. I am aware that you all have worked in such a high temperature during the entire day. You all are tired, and despite of that you are attending this lecture, but I'll request everyone present in the hall that for next 60 to 70 minutes you all have to give attention to the topic. The topic is of immense importance. The topic is of extreme importance to we all civil court practitioners as well as criminal law practitioners. The reason I am saying that this is of immense importance is that the temperament, or you can say that legal culture, is going to be changed by way of this particular act. We all are aware that in the corridors we talk about some lawyer that he is a criminal lawyer expert. We talk about some lawyer saying that he is a civil court expert, he is a practitioner of civil law. So now in coming time, a new specialization would develop, and that specialization would be a commercial court lawyer or a commercial court expert. You believe me that in next 5 to 6 years, this Commercial Court Act is going to change the entire complexion, entire nature of judicial system. You all are aware that whenever we lawyer sit amongst our friends, family, or wherever we go, the only criticism we all face is the delay, isn't it? Everybody speaks about delay. Everybody speaks that how much time you guys take to decide a suit, how much time it takes to decide a case. So in order to solve this problem, this criticism, this particular legislation is now in place. Friends, we all are experienced lawyers. We are practicing since whatever 2 years, 5 years, 10 years. We have observed that a civil suit, if it is lodged, nobody knows that when the judgment or the decree would be passed. But here is the legislation that is going to tell you that when would your judgment and the decree would be passed. And therefore I am telling you that this particular legislation is going to change the entire nature of judicial system in our country. This is the law of future. Now, coming to the introduction or coming to the inception of this particular concept, in 253rd report of Law Commission, it was observed that foreign national companies, foreign direct investment, economic growth, and economic development is happening rapidly in India. And when the foreigners used to look at India, they used to assess India in terms of ease of doing business. When foreigners feel that doing business in India is probably easier, but getting justice in India is extremely difficult. So in order to solve this problem, 253rd report of Law Commission observed that such type of legislation is important. And therefore, to achieve economic growth and in order to improve the image internationally of Indian justice delivery system, this particular legislation was introduced. One more very major objective was there, and that major objective was improving the legal culture. Friends, when I am saying that improving the legal culture was one of the objectives, what is legal culture? You guys must have heard or must have talked on your own that a lawyer is a big liar, or you must have heard that lawyers never speak truth, and therefore the perception of common people to look at us is like that these lawyers always lie in the court of law, and they always speak something which is not true. But now the law expects you to be a very truthful lawyers, and therefore the term used is improving the legal culture in India. Now I must tell you in the beginning itself that this particular legislation is not changing any substantive law. What is being changed is only a procedural improvement. Now coming to the next slide, I hope you are having that presentation printout also in your hand. Whoever are able to concentrate on the screen is fine, and whoever are having the printout, you can just turn on the pages next. So now coming to the fourth slide or the fourth page, I will just highlight the 10 major drastic changes which are made by this particular legislation. Now what are the highlights of the act? Kindly have a look at the PPT presentation. Mandatory pre-institution mediation and settlement. You all are aware that alternate dispute resolution is being promoted everywhere, but it is merely promotion. It was merely canvassing, or it was merely a request to the litigants that you please go to ART and try to explore the possibility of settlement. But now, for the first time in India, this legislation has introduced mandatory pre-institution mediation and settlement. That means that unless you go for mediation, your suit will not even be numbered. Kindly note, your suit will not be filed in the court of law. This is happening for the first time. Now come to the next. Strict time limit provided for each stage. Time limit for completing pleadings, discovery, inspection, recording of evidence, and even for passing judgment is introduced. That means within how much days a judge should pass the judgment, that is also introduced and prescribed under this new legislation. Now coming next, law of pleadings is codified for the first time in India. Affidavit format, that is known as statement of truth, is introduced for the first time. Now next, summary judgment is introduced. Now what is this summary judgment? Please appreciate that the way a high court decides a case, the way high court just hears the argument from both the sides without even going into the evidence recording, without even recording the evidence, a trial court would be able to pass a final judgment, and that is a summary judgment procedure, and that is introduced for the first time. Now coming to the next, case management hearing. I will just give you an example that you might have seen in some movie, Hollywood movie probably, that a litigation is going on in court of law. A judge is sitting in between, parties and lawyers are sitting across the table. They both share a cup of coffee and then they discuss and decide how their case would proceed. Exactly in similar fashion, though this type of filminess would not be there, but in same fashion the judge would sit and decide a particular date, that on which date you will file your evidence affidavit, on which date you will cross-examine the witness, on which date you will complete the inspection of document, and on which date the final argument would take place. And thereafter, the final judgment date would also be declared at the initial stage itself. And all this is called as case management hearing. So this new concept from American judicial system is introduced for the first time in our system. Now coming to the next, limits on cost and penalties removed. You are well aware that whenever you default in a civil trial, the court generally put you to a petty cost like 3,000 or something like that. But now the limit on putting this cost is completely removed. The cost on a defaulting party would go in lakhs and crores. I'll give you an example to that effect. Now next, written argument are made compulsory. Initially, whenever we used to conduct civil trials, you all are aware that such type of making it compulsory to file written argument was never there. But now in new legislation, such type of compulsory written argument are made. Time-bound oral arguments in our type of judicial system, which is completely overburdened with the work, pendency is huge. In such situation, a lawyer who argues for hours together, our system cannot afford such lengthy arguments. And therefore, a judge is now empowered to give a particular time frame and time limit for written arguments. And the last one is that this legislation is a single appeal legislation. That means you all are aware that at every stage, whenever you file some petty application, you approach to High Court, you approach to higher court and request the court that, see, this has not been done, you stay the trial remains stayed for years together and the suit gets delayed. So all these type of aspects which used to delay the outcome of a civil suit are all taken care by this particular Commercial Courts Act. Now coming to the next slide. Friends, I have given you the highlights of this particular act. Now we will discuss each one of it in detail. Are you finding it something new? Friends, may I ask you that how many of you have handled a commercial court suit as yet? Anybody is there? So nice of you that you are having so many lawyers who are present here, who have already handled. So while taking that question answer session, we can discuss the practical difficulties also. Now coming to the next slide, it says the legislation is aimed to resolve all disputes which are commercial in nature. The legislation is a step ahead to improve India's rating in ease of doing business. Now, what is commercial cause of action, or what is a commercial nature of a dispute? The word commercial relates to trade, commerce, business activity or profit activity. In a short, अगदी थोडक्यात सांगायचं तर कुठलाही व्यवसाय, कुठलाही कमर्शियल आस्पेक्ट, मग तो साधारण पानपट्टीवरचा दुकानदार असो किंवा दूधवाला असो, कुठलाही ट्रेड So the word commercial relates to trade, commerce and business. Now the definition is there in the Act. I will just read the items or the aspects which are covered under the Commercial Suits or the Commercial Courts Act. Ordinary transactions of merchants, bankers, financiers, traders relating to mercantile document, export, import, mercantile or services, admiralty, maritime law, transaction relating to aircraft, helicopters, carriage of goods, construction and infrastructure contracts including tenders, agreements relating to properties used exclusively in trade or commerce, agreements related to franchisee, distribution, licensing, management consultancy, joint venture, shareholders, and so on. The list is long enough. It includes 22 items, but please appreciate that for we lawyers who are dealing with a civil type of or civil practice, they have to just keep it in mind that any business activity would probably brought under this particular act. Now, what are going to be the benefits of bringing this particular cause of action or this particular suit under Commercial Court Act? You would come to know gradually when we proceed ahead in the lecture. Now, I'll request for next slide. There is one explanation given in the Act. This is going to be a little technical or monotonous, but friends, please, I am requesting your attention for few more minutes. This is very crucial and important topic for civil practice, and therefore I am requesting you, please give your attention for another 50 to 60 minutes only. Now, kindly have a look at the slide. The slide says, a suit may not lose its character of commercial dispute because recovery of immovable property, realization of money out of immovable property given as security or any other relief pertaining to immovable property is sought. Now, focusing on this aspect of explanation, many a times it happens that suppose a property is given on license basis to a hotel business for conducting the hotel business. Now, this is a trade, this is a commercial object, no doubt about it. But the plaintiff comes to a court with a case that, see, my conducting agreement is over. It is terminated. But this particular conductor of this hotel business has illegally retained the property. So then the question would come that whether in such circumstances, whether commercial court would come in picture or no. A defendant would come and take a defense that, see, he has sought possession of the property. He has not sought any relief in respect of this commercial transaction. So whether such type of disputes which are touching to the property which was involved in a commercial transaction, whether you can file a suit under Commercial Court Act or no is the question. So that aspect is taken care. If any property is involved in commercial transaction, you can file a suit under Commercial Courts Act. Now coming to the next explanation. State is one of the parties. You are well aware. Take an example that your client comes and says that, see, I have bidded for this particular tender. The tender was issued by MCGM or tender was issued by the state government. The moment we see it at this is a tender matter, you advise your client, no, you go to High Court. No, trial court would not be able to deal with it. So now that aspect is completely stopped. Why? Because the Act says that even if the respondent, even if the defendant is a state government or a government body, you can still maintain a suit against government. Only thing is, it should be of commercial in nature. Now coming to the next slide. Now, most important, the first question a lawyer would ask is that what should be the specified value? What would be the valuation of a particular suit? See, initially when this particular Commercial Courts Act was introduced, the amount, monetary value was rupees 1 crore. So the disputes which are touching to rupees 1 crore, only those type of disputes used to come to the Commercial Courts Act. However, in 2018, the amendment was introduced, and the amendment brought down the monetary limit from 1 crore to 3 lakhs only. So kindly appreciate that even if a small trader, a small time businessman, even if a stationery shop owner, even if suppose a Maruti 800 car is involved in a transaction, every small aspect can also be brought under Commercial Courts Act. Now just see the specified value. Value of the subject matter of the suit shall not be less than rupees 3 lakhs. Prior to 2018 amendment, it was rupees 1 crore. Now, how to determine a specified value of the subject matter is provided in section 12. Now, 12.1, kindly appreciate, now the role of plaintiff would come. While valuing your suit, how do you value a particular transaction? Kindly have a look at this. If it is recovery of money, specified value will include interest till date of filing of the suit. We must have come across such type of litigations which says that no, you have to claim only principal. Don't include that interest part in your claim. Have you come across such type of objections? So to remove that objection part, the Act says that if it is a recovery suit, you have to include even the interest part, and then it should reach rupees 3 lakhs and then come to Commercial Courts Act. Now coming to next, movable property or rights therein. Its market value on the date of filing suit. We as a lawyer are well aware that market value of a particular aspect is a very hazy subject, is a very slippery subject. See, what I feel is a market value, what you feel would also be a market value, that amount would be different. So, in some type of transactions, the plaintiff would say that no, I feel the value of this particular transaction is rupees 3 lakhs. So, you have got liberty, you have got freedom to assess your claim on your own on the basis of market value. Now, coming to the immovable property, same. Market value on the date of filing suit, and thereafter intangible rights. Now, intangible rights, you are aware about intangible rights. What is that? Intangible right, intellectual property rights. So, if you feel that, see, the copyright or the trademark infringement is costing rupees so and so, so you have got the discretion. So, that is, you have to value your suit. Now coming to the next slide. Now there are constitution of commercial courts. We will not waste much time on this, but commercial court at district level, commercial appellate courts at district level also. But now since we are having this high court original jurisdiction, it would not be applicable to our courts, but a commercial appellate court at the same district level. So kindly take a case of, say, Kolhapur or Satara. In Kolhapur or Satara, in the same district court premises, the district judge of same cadre would be having status of a commercial court, and the other court would be a commercial appellate court. So this is what the thing is. The first appeal would be in the same court itself. Now, commercial division of High Court, a single judge would be the commercial division, and commercial appellate division would be the division bench of High Court. Now, coming to the next slide. Now, coming to section 12A, mandatory pre-institution mediation and settlement. In a suit, kindly note the first line. In a suit which does not contemplate any urgent relief. So, if it is a money suit, if it is a recovery suit, if it is having some property related issue, so having no urgency, so in such type of suits, mediation by authorities authorized under Legal Services Authorities Act This mediation is to be completed within 3 months. Now I will request every one of you that every stage now I am going to tell you the time duration or the time prescribed by the act. Kindly keep it in mind that if this particular duration or the prescription of the time is past or expired, then as a lawyer you have to keep it in mind that that particular stage cannot be resorted to, cannot be gone into at a later stage. What I mean to say that if a particular aspect, say inspection of document, is going to be taken place within 15 days only, on 16th of day, the other side would lose that opportunity forever. Please keep it in mind forever. Now coming to this mediation part, mediation by authorities of legal services, this is to be completed within 3 months completely. Extension of 2 months can be granted, that too only with the consent of the parties. The settlement will have the status of arbitral award under section 30 subclause 4 of the Arbitration and Conciliation Act. Non-compliance will result in rejection of the plaint order 7 rule 11. A judgment is referred on the board. Messrs. Patil Automation Private Limited versus Rakheja Engineering Private Limited. Very interesting case it is. Friends, kindly note, in this particular Patil Automation Private Limited case, the matter reached up to the stage of judgment, and that stage the defendant took the objection that, see, in this particular act mediation was made compulsory. Plaintiff did not opt for this compulsory mediation and proceeded ahead with the suit. High Court took a view that mediation can be done at any stage. What is wrong in that? If now the suit has reached to the stage of judgment, let us go ahead. But Supreme Court says no. If mediation is provided as a pre-institution to the suit, before the suit starts, in that event, such type of proceedings have to be cancelled. The plaint was returned to the plaintiff. The plaintiff was to start from zero completely. Very interesting case. I'll request all of you to go through this particular case. So therefore, mediation is essential. Now coming to the next slide. Now section 16. Now this is probably the soul of this particular legislation. Amendment to CPC in its application to commercial disputes as specified in the schedule. Section 26 and Order 6, Rule 15A. Now facts in the plaint and subsequent amendments shall be proved by affidavit. We all are aware that whenever we file a suit, we affirm the plaint and all that. But now, for the first time to the lawyers of India, the legislation is trying to teach the law of pleadings. The law of pleadings was never codified in the past. For the first time, the codification of pleadings is happening. Kindly have a look. I am requesting all of you that if you fail in following the rules of pleadings prescribed under the Act, your entire suit will fail. If the defendant fails in following the rules of pleadings or the mandatory nature of these provisions, your defense would be striked out. Now let us go ahead. What is the requirement of pleadings is? Affidavit shall be prescribed in the format in Appendix 1, and this Appendix 1 format is known as Statement of Truth. What does it mention? It mentions about competence of the party, which pleadings are as per the personal knowledge and which are as per the information received and which are as per the legal advice. You are well aware that we mentioned that I so and so say that pleadings in para number 1 to 5 are as per my knowledge and all that. But you will have to also mention that who I am, whether authorized by a board resolution, whether I am a director, whether I am a partner, whether I am an independent proprietor of a firm, and what authority I have to depose or to sign this particular plaint before the court, and also mentioned that this particular paragraph is as per the knowledge, this particular is as per the instruction given by the lawyer, and etc. So this appendix 1 statement of truth, we all should have saved this particular format in our computers. Whenever you are going to file a suit under Commercial Courts Act, your steno or you yourself should ensure that your affidavit is coming in the format of statement of truth only. Now coming to the next. Non-compliance will disallow the reliance on such pleadings as evidence. The court may strike out non-verified pleadings, pleadings without statement of truth. So this power is introduced with the court for the first time. Now coming to the next slide, Order 7, plaints in money suit, Rule 2A be added. Where interest is sought in a suit, plaintiff shall state whether the interest is claimed as per section 34 of CPC. It is becoming very technical, is it so? Getting bored or what? So now coming to this section 34 of CPC, or under the terms of contract or under an act or some other basis, details have to be specified. I'll just remind you that I have seen plaints stating that so much of amount is taken by the defendant from me as a friendly loan, and now the defendant has to pay the interest at the rate of 18%. Few lawyers have written 24% or whatever or what not. I have also seen plaints claiming 36% rate of interest. But friends, now gone are those days. You have to mention that if you are claiming particular rate of interest, on what basis you have calculated this rate of interest, whether there was any agreement between you both, whether there was an invoice where you have written that delayed payment would attract interest, whether there is any provision, whether there is any other understanding between both of you which entitles you to claim so much of interest that you have to justify. Just merely stating that I am entitled for 8% rate of interest will not suffice. Your claim would be dismissed, and not only dismissed, you would be put to the cost for wasting the court's time under this particular legislation. Therefore, while claiming rate of interest, you have to state the source. You have to state what is the basis for such claim. Now, pleading must state rate of interest, duration, total amount of interest claimed, and daily rate at which interest accrues after that date. Now, coming to the next slide. Now, this all is about plaintiff and all that. Now, coming to the defendant side. You received a summons. Now, you are supposed to defend your client in a commercial court suit. Now, what is your role as a lawyer for defendant? You are all aware that after receipt of the summons, 30 days you have to file written statement. If not, then you have to give reason. The court will extend the time. You are well aware about these proceedings and provisions also. Now tell me one thing, that once we file this written statement hastily in a normal suit, nobody is aware that when would your suit be decided, when would your evidence be recorded. Nobody is aware. Then why are you making haste to file written statement? Why this concept of filing written statement in 30 days and then do nothing for 20 years? Why? What sort of law it was? Now the entire concept is changed. You will get little more time for filing written statement. Little more time means what? That you will get 120 days with some reason, no doubt 30 days limit is there, but if you cannot file written statement in 30 days, you will get extension till 120 days. You will have sufficient time to frame your strategy. You will have sufficient time to defend the suit in your written statement appropriately. But once you file written statement, you will not have any time to even breathe for completing your evidence and to take the judgment or the decree in the suit. This is what the new concept introduced, that filing written statement would get little more time, but trial would be time bound. Now see how it goes. It is mentioning that commercial suit, the duration, the time limit for filing written statement is 30 days, but not beyond 120 days. That too on the reasons to be recorded in writing and on the payment of cost. Most important part now, last line. After 120 days, right to file written statement gets forfeited and written statement will not be accepted. Now, friends, please note that if you receive a summons in Commercial Courts Act matter, keep it in mind. Inform your client that after 120th day, forget about Supreme Court, even the President of India cannot allow you to take your written statement on record. I am little exaggerating, but this is the law. The Supreme Court has held in various judgments that the law says that after 120 days, the right to file written statement get forfeited. So therefore, you have to follow this 120-day limit very meticulously. Now coming to the next slide, Order 8, Rule 3, denials in the written statement to be specific. Friends, I have seen plaints and written statements, 2 pages plaint and 1 page written statement. I have seen that type of proceedings. I have also seen proceedings where the suit is of 20 pages, whereas the written statement is of 70 to 80 pages. All argumentative, all mentioning the law, judgments, your logic, your imagination, what not. But now that type of practice is completely stopped and closed. Forget about such type of written statement in civil cases now. Now written statement, the defendant has to mention, kindly look, defendant to state as to which allegation he denies and reasons for the same, and state his own version if different from given by the plaintiff. The defendant has to state which he is unable to admit or deny, which he requires the plaintiff to prove, and which he admits. If disputing the jurisdiction, reason for the same, state as to which court ought to have jurisdiction. If disputing valuation of the suit, reason for the same, and furnish his own statement of the valuation. Order 8, Rule 5, Sub-Rule 1, after the first proviso, if denials are not specified in Rule 3A, the allegations shall be taken to be admitted except against a person under disability. So, earlier we used to just make a bald statement, a generalized statement. I hereby deny all the contentions averment in the plaint contained in paragraph number 1 to 30, 1 to 20, whatever. So, general denials would not help you at all in Commercial Court Act matters. You have to specifically deal with each and every paragraph. If you are denying, why? If you cannot deny, or if you don't have any knowledge, mention that I don't have any knowledge. If you admit particular thing, you have to mention. Now, I told you in the beginning that culture of our law practice is to be changed. So now the reference comes here. if you are defending a case, you have to state only truth. If you are aware about a particular aspect, you have to say that I am aware about this aspect, but I am denying this particular aspect also. Don't generalize your defenses. Why I am saying that? Because if you mislead the court, if you waste the court's time by generally denying everything and anything in the plaint, that would attract cost in the end. I am going to tell you on that. Now coming to the next slide. Now disclosure, discovery and inspection of document. I am well aware that few of you are also into the arbitration practice. You are probably handling arbitration matters also. In arbitrations, we generally carry out this practice of disclosure, inspection of document, and also the discovery, etc., interrogatories. So the similar practice is going to be there in a commercial court's proceedings. A plaintiff and defendant shall file along with a plaint and written statement respectively. Now kindly note very important things. List of all documents and its photocopies in his possession, irrespective whether supportive or adverse. Friends, please believe me, every word on the board, every word on the note is having significance and a mandatory nature provided in the legislation. A document, even if it is adverse to you, even if it is against your client's interest, then also you are duty bound as a lawyer to produce that document. I am going one step ahead. Whatever documents you have to file all the documents at the stage of filing of plaint or written statement. You are well aware that earlier the practice used to that after 2-3 years, when you have to kill the time or when you have to avoid the particular court, you used to file an application production of document. You used to write the reason. क्लायंटला आत्ताच हा कागद मिळून आला, आत्तापर्यंत त्याला हे माहीतच नव्हतं, परवा त्यांनी शोध घेतल्यावर हा कागद सापडला, and therefore I have come across such document and I am producing this document because it is very crucial, important. No. Now while filing the suit, you have to produce all and every document. Later on, no production. Kindly note. Nature of document you have to state. Whether it is the original, whether it is office copy, photocopies, details of the parties to each document, mode of execution, issuance or receipt. Declaration on oath that the documents are pertaining to the proceedings and same have been disclosed and annexed with the plaint, and he does not have any other document. Statement of truth as per format in appendix. So you have to file a affidavit stating that आज मी जेवढं प्लेंट बरोबर सादर केलंय त्याच्याशिवाय आता माझ्याकडे कुठलाही कागद नाही, अशा प्रकारचा affidavit तुम्हाला दाखल करणं गरजेचं आहे. So kindly note this. Now in case of urgent filing, you will say that see, this is all right for a money suit or this is all right for a suit, normal suit. But when it is an urgent suit, then what? In urgency, when client comes to us, he doesn't even aware that what he is supposed to give it to lawyer. Many times very important and crucial documents are missed. In such eventuality, seek leave to file additional documents. If granted, to be filed within 30 days along with affidavit of truth. That means the day you file the suit, you are excused that you are not filing all the documents. But take leave on the same day from the court. That also you will get only 30 days. Tell your client to search all the documents within those 30 days. Thereafter, no. Now come to the next. No additional document will be allowed to rely which were not disclosed earlier without leave of the court. Such leave will be granted only upon establishing reasonable cause for non-disclosure. Details of the document which plaintiff seek production from the defendant has to be mentioned. Discovery by interrogatories in 10 days. Now see, discovery by interrogatories in 10 days. If you go to the website, you will find all the formats. How to seek production of a document, how to seek interrogatories, all the formats are available on the website. You have to just follow their prescribed procedure and formats. Don't apply your logic and don't say that what happens in last suit I did that, I will just write something and give it to the court. No. For commercial court matters, you have to follow the formats given in CPC only. Now come to the next. Admission and denial of documents within 15 days of inspection. Denials without reason would attract cost. See, म्हणलं की generalized denials without reason would attract cost. Easy and special provision are made for production of documents and electronic record. तुम्हाला माहिती आहे ते electronic record, we have to give that affidavit and all that this was my computer, this was under my possession, it was not faulty and etc. etc. So all that procedure is also extremely simplified in Commercial Courts Act. We are not going into that topic in detail, but kindly take note that a video recorded by a client on his mobile, production of that particular evidence, the procedure is extremely simplified. Now come to the next slide. Section 35, discretion to decide whether costs are payable by one party to another, its quantum and the stage of its payment. Cost will include fees and expenses of the witnesses, legal fees and expenses incurred and any other expenses. Now right hand side portion is very important. Generally, unsuccessful party will be ordered to pay cost. But here in the new legislation, the court can deviate from the general rule by recording reasons for the deviation. Now I'll give you an example. Your client has filed a suit for money decree and also added the portion of damages. You claimed that this particular defendant has defaulted on payment of so and so money and therefore I require to recover this particular amount from the defendant and therefore damage is caused, so I am entitled for damages also. The court decrees your suit in respect of money decree. The court says that yes, you have paid him by check, he was supposed to return back, he did not return, so therefore money decree granted. But if you failed to establish the damages part, if you failed to establish before the court that there was any damage occurred to you and therefore you are not entitled to any compensation, then the court will put you to heavy cost for wasting court's time. So ask what is correct. So pray what you are really eligible or entitled for. Only because I am having a good case on recovery, I will add some compensation, I will add some damages and I will try to greedily recover more amount. Such type of approaches are required to be dropped. Friends, please note, all these aspects are going to be very crucial in future for a civil practice. Now see this. While computing the cost, what part is going to be covered by the court? While making cost, the court shall have regard to conduct of the parties. Just note it. Conduct of the parties. Success of a party on part of its case, even if not wholly successful. Making frivolous counterclaim to delay the disposal of case. reasonable settlement offered by one party and unreasonably refused by the other party, frivolous claim and vexatious proceedings wasting time of the court. So I'll just explain you that in a settlement proposal, if the defendant gives a very reasonable offer to you, if the defendant gives genuine and bona fide offers that, see, this was the amount, I was in difficulty, whatever happened, I am ready to give your amount principal plus a very petty amount of interest and all that. But you advise your client, or your client feels that no, चांगला सापडला आता. Now we have to satisfy our ego. Now we have to see that he faces the judgment, and you refuse to accept for settlement. In such eventuality, kindly note that court is watching you. Court is recording your conduct. If the court forms an opinion that the offer given by defendant was genuine, was bona fide, but plaintiff, just to satisfy his ego, did not accept that settlement offer, please note that such aspect would be put to cost by the court, and therefore legal culture, again I am going to the first object to introduce this act. You are expected to be very genuine and honest. Now friends, I'll just pause here for a moment and I'll give you an extremely celebrated case of our Bombay High Court on this topic of cost. The judgment is mentioned there on the PPT. Jayant Industries versus Indian Tobacco Company. Now this Indian Tobacco Company is having a cigarette brand by name Classic. Now their trademark and copyright, the design, all is registered in 1979. Now this Jayanta Industries, it claims that this plaintiff's grandmother and grandfather started this brand name by name Classic in the year 1968. And they used to manufacture what? Sanitary products, some ashtray, room fresheners and etc. And therefore this Jayanta Industries comes to the court with a claim of 2100 crores against Indian Tobacco Company, saying that Indian Tobacco Company has stolen our trademark and copyright of this Classic brand, and they are selling their cigarettes by this Classic name, and therefore put them to the compensation of 2100 crores. Now this ITC comes in the court. They point out to the court that the entire claim of the plaintiff was dishonest and fanciful. How I will tell you. In order to establish that this particular company, Jayanta Industries, was manufacturing these products since 1968, the plaintiff produced certain invoices or bills. Now those bills were issued by a trader in Andheri. The bill was mentioning that Jayanta Industries has supplied product of so and so quantity, etc., etc. is the amount, and we have received this product. This was the receipt. Now this bill was of 1968 to 74. On this particular bill, the address of Andheri dealer was there. The address mentioned the pin code 400XXX something, that postal pin code. Now this defendant ITC approaches the postal department and asks postal department that since when you have started this pin coding system. So they said after 1986 we started. Now kindly see, the plaintiff has produced a bill of 1968 issued by a Andheri dealer, and on that particular bill, the pin code is mentioned 400001 or 00 whatever extra. So it was apparently a forged document, apparently a created document. When postal department itself started this pin code practice in 86, you are issuing bill with this false pin code number, so it was wrong. One more aspect, this particular dealer mentioned the phone number of this shop. The phone number was of 7 digit. You remember that earlier 10-15 years back, the phone number used to be 4-5 digits, something like that. So this ITC company approached to the MTNL and asked them that since when you started this 7-digit number. They also gave answer that recently we have started, and now 68 bill says that 7-digit phone number. So this was demonstrated before the court of law that this particular suit was completely fanciful, bogus, and it was dishonestly filed. There were several other aspects also. But when the court realized that this was a fraud played upon the court asked the defendant that you give whatever the cost you have incurred to defend the suit. You are aware that senior counsels in Bombay High Court, how much they charge. You are well aware. So they gave a bill of rupees 1,21 lakhs to the court with proper check entries that this was the actual expenses we have incurred for defending the suit. The court said that 1,20 lakhs, 21 lakhs is required to be awarded to the plaintiff, but out of sympathy, but out of the consideration that this plaintiff was 28 years young lady, the court put her to the cost of rupees 60 lakhs, 60. So the reason I mentioned that the cap or the limit on putting the cost is removed, the reason I mentioned to you that your honesty is going to matter a lot, the reason I mentioned you the legal culture is going to be changed in our country is this. So friends, I will request you while going to home, whether if you can take this particular judgment on your mobile or whatever possible, I will request every one of you to just go through this judgment. This is an excellent piece of judgment by Justice Kulabawala of our Bombay High Court, narrating all the facets, all the aspects of this Commercial Courts Act and how honesty is required from lawyers. Now coming to the next slide. Isn't it interesting case law? Please read, please read. I am telling you, I am requesting, young lawyers are also there, I am requesting every one of you that you must go through this judgment. Now coming to the next section, section 35, subsection 35A, subsection 2 shall be omitted. It was about quantum of the cost, not to exceed rupees 3,000 or exceeding the limits of pecuniary jurisdiction, whichever amount is less. This was omitted by this particular act. Coming to the next slide. I know 1 hour is past, just I'll wind up in 10 minutes. You have patience or getting bored? Wind up? Chalo, just give me 10 minutes, I'll finish. Now section 8. No civil revision application, petition against any interlocutory order or commercial court of commercial court, even on jurisdiction issue, but it has to be raised in final appeal as per section 13. So I told you initially itself that whenever something wrong happens in trial courts of other districts, there is a practice of filing purshis. Those ladies who are from other districts or probably the old senior most lawyers would be aware that we used to file some purshi in the court. The court used to pass some order. We used to take certified of that Pursi and go to the High Court, go to Appellate Court, request the courts. This is the illegality. You stay the suit. The court used to issue notice, stayed the suit. For years together, the suit used to remain pending. Now, by this particular legislation, there will not be any revision application, there will not be any petition, writ petition, nothing. Start the suit and take the final decree. No in between visits to High Court at all. Now see section 12 subclause 3. Determination of specified value, that is pecuniary jurisdiction. Even such order cannot be challenged in civil revision application or appeal during ongoing trial. Next slide. Appeals from decrees to commercial appellate court within 60 days from the date of judgment and order. However, now note this. Appeals would lie from orders enumerated under Order 43, that is appeal from orders of CPC and Section 37 of Arbitration and Conciliation Act. In short, Exhibit 5 application, injunction application, we file appeals to the High Court on that or the Appellate Court. So that single appeal is allowed. Order 43 appeals are allowed, but none others. Now see section 14. Appellate court shall endeavour to dispose of appeals within 6 months from the date of filing of the appeal. Now coming to the next slide. Summary judgment. Now what is this summary judgment? Court may decide a claim or part of claim or any particular question without recording oral evidence. Application to passing summary judgment can be filed after summons is served but not after framing of the issues. Now kindly see this chronology. Summons is served but before framing of the issues. That means this is completely focusing on the aspect of pleadings. If your plaint is not as prescribed under the Act, if your written statement is not as per the requirements of the Commercial Courts Act, the other side will immediately point out to the court that see, the pleadings are incorrect. There is no likelihood that the court can rely on such pleadings which are not in the prescribed format, and therefore you pass the final judgment itself. So kindly see, I'll read it again. Application to passing summary judgment can be filed after summons is served, but not after framing of the issues. Hope everybody has understood that. Now what should be the ground of summary judgment? A plaintiff can plead for summary judgment or a defendant can plead for summary judgment when one party has no real prospect of succeeding in the case, and most important, there is no other compelling reason to refuse to do so. Means court just want a good reason that the court should avoid recording evidence and pass the final judgment. Unless there is some compelling reason, the court will not say no. You have to just find out the lacuna in the pleadings. The reason I mentioned to you that there would be expertization, specialization in commercial proceedings is because of this. As a specialized lawyer, you have to keep it in mind that if this is a Commercial Courts Act, check CPC, word to word same. If the pleadings are as per the format, all right. If not, file application for summary judgment, take the judgment, finish. This is what is going to be the future. Now coming to the next. See, I'll just repeat it once again. Summary judgment म्हणजे काय तर without recording any evidence तुम्हाला final judgment घ्यायचं आहे. तुम्ही जर हायकोर्टामध्ये बघत असाल तर हायकोर्टामध्ये आपण पिटिशन फाईल करतो. हायकोर्ट म्हणतं अदर साईड काय रिस्पॉन्डंट टू फाईल रिप्लाय, रिस्पॉन्डंटचा रिप्लाय येतो, पिटिशनरची केस वाचल्या जाते, रिस्पॉन्डंटची केस वाचल्या जाते, काय प्रॉपर आहे त्याप्रमाणे जजमेंट दिल्या जातं. सो दिस इज समरी जजमेंट. आता ही पॉवर सिटी सिव्हिल कोर्टाला दिल्या गेली आहे, सिव्हिल कोर्टाला दिल्या गेली आहे, पण त्याची एक विंडो दिली आहे, फ्रेमवर्क दिला आहे की तुम्ही कधी हे ॲप्लिकेशन करू शकता. ते ॲप्लिकेशन कधी करू शकता, तुम्हाला समन्स मिळालं, समन्स मिळाल्या तुम्ही ॲज अ डिफेन्स लॉयर, ॲज अ डिफेंडंटचं लॉयर बघायचं की प्लेंट कमर्शियल कोर्ट ॲक्ट प्रमाणे आहे की नाही. असेल तर ठीक, जर स्टेटमेंट ऑफ ट्रूथ नसेल, जर स्टँडर्ड फॉर्मॅटमधलं ॲफिडेविट नसेल, इमिजिएट ॲप्लिकेशन करा की हा सूट चालू शकणार नाही, जजमेंट द्या. सिमिलरली, when you file written statement, the plaintiff will check that whether your pleadings are proper or no, whether your defense is proper or no, whether your denials are appropriately taken or no. If your denials are not in proper format, the plaintiff will make a application for summary judgment saying that काही ह्याच्यामध्ये केसच नाहीये, यांनी काही घेतलेलं नाहीये, स्टँडर्ड फॉर्मॅटमध्ये समरी जजमेंट द्या. आणि इमिजिएटली विदाउट रेकॉर्डिंग एव्हिडन्स the city civil court will pass the final decree. This is what the summary judgment is. Legislation. तुम्ही जर आता आपल्या जरी सिटी सिव्हिलच्या वेबसाईटवर जाऊन बघितलं ना, कोर्टरूम नंबर 32च्या ऑर्डर, कोर्ट नंबर 33 किंवा दिंडोशीच्या कोर्ट नंबर 2, 3, 5च्या ऑर्डर्स, these are the commercial courts in city civil court. You are well aware. Court number 32, 33 is the commercial court here. If you see their orders, the court, our city civil court has passed a specific time frame. या दिवशी प्लेंटिफ एव्हिडन्स ॲफिडेविट फाईल करेल, या दिवशी तारीख दिली जाते, या दिवशी डिफेंडंट त्यांचा क्रॉस एक्झामिनेशन करेल, डिफेंडंटचा एव्हिडन्स या दिवशी रेकॉर्ड होईल, वगैरे वगैरे. रिटन आर्ग्युमेंट या दिवशी दिल्या जातील, ओरल आर्ग्युमेंट या दिवशी होतील, आणि फायनल जजमेंटची तारीख सुद्धा लिहिलेली आहे. आय विल रिक्वेस्ट एव्हरी वन ऑफ यू, कोर्ट रूम नंबर 32च्या ऑर्डर्स चेक करा. कोर्ट रूम नंबर 32च्या ऑर्डरमध्ये त्यांनी केस मॅनेजमेंट हिअरिंग कंडक्ट केलेल्या आहेत. आता काय काय केस मॅनेजमेंट हिअरिंगमध्ये, प्लीज नोट. केस मॅनेजमेंट हिअरिंग वुड डिसाइड फर्स्ट हिअरिंग within 4 weeks from all the parties file their respective affidavits and admission or denial of document. Now, the court will frame issues, listing of the witnesses, lay down fixed dates for filing evidence affidavits, recording of evidence of witnesses, fix the date of filing written argument, oral argument, and time limit for oral argument, fix time limit for completion of the entire trial, which is not later than 6 months from the first hearing, recording evidence on day-to-day basis, to hold such case management hearing during the trial to facilitate speedy disposal of the suit. Failure to comply with the case management hearing orders will attract payment of cost, foreclose of right to file affidavit, right to cross-examine, right to file written argument, right to oral argument, dismiss the plaint, allow the suit. After conclusion of the argument, the court shall pronounce judgment within 90 days and send the copy to parties by email. Case management hearing are to be conducted even in transferred suits as per section 15(4) of the Act. म्हणजे केस मॅनेजमेंट हिअरिंगमध्ये काय करायचं आहे, what we are supposed to do, what the judge is supposed to do in the case management hearing. The case management hearing would lay down the entire schedule of dates. The final date of judgment would also be mentioned in that. On what date you have to do what would be mentioned, and you have to follow that schedule very meticulously. If you fail to follow any of the date, if you fail to follow that schedule given by the case management hearing, your right to do anything like cross-examine the witness or file affidavit or file written argument or make oral argument, everything, anything, the court would say that you have lost your chance to do that. So therefore, there will not be any compromise, there will not be any excuse to deviate from the schedule. The schedule which is framed in the case management hearing would be final. That means what? You know, your client would be having a clear picture in his mind that whatever happens, the judgment will be available on this particular date in my case. This has never happened in India. तुमच्या क्लायंटला तुम्हाला सांगता येईल की बाबा डिफेंडंटनी काही करो नाही तर न करो, तुझी डिक्री पॉझिटिव्ह का निगेटिव्ह माहीत नाही, पण या तारखेला तुला ईमेल येणार. If you remember that even for obtaining the copy of judgment, we people used to manage the things in department. You all are aware. Because we are law practitioners, I can speak frankly with you. Just to delay or extend the period of appeal, what you used to do, you say that आज माझा अर्ज घ्या सर्टिफाईडचा, बनवा आरामात, रेडी लेटर दाखवा. Now gone are the days. You will get the judgment copy in your inbox on email and the limitation would start on that particular day. See what is expected by law. See what is being provided for next generation. See how the legislature has eliminated, ruled out all the possibilities which used to delay a suit. Everything is removed with proper study, and therefore you have to carry Commercial Courts Act in your hand. You have to study Commercial Court Act repeatedly again and again. You have to follow the time schedule very meticulously. Now coming to the next slide, powers of the court in case management hearing. Just have a look at the powers. Extend or shorten the time for compliances. Strike off witnesses or evidence which is irrelevant for the issue framed. Recording of evidence by commission. Reject or strike off evidence affidavit or its part containing irrelevant, inadmissible and argumentative material. No adjournment on the ground of absence of advocate. You please change the So no adjournment on the ground of absence of the advocate. My senior is in personal difficulty today. No. Now this reason will not work for a commercial court. Please note, specifically provided in the Act, absence of the advocate is no excuse. You change advocate or you do whatever, but you can't give an excuse that my lawyer is absent, take me another date. No. My senior is detected with COVID positive, take it. No. The law says no, means no. Kindly see this. Non-compliance of order passed in case management hearing will invite drastic orders, forfeiting all the rights to conduct the case. Now, next slide. The question would be asked that what happens to the old cases? What happens to the cases which are already filed and pending since years together? So the next slide answers that. It says that it is applicable even in all the suits and applications, including applications under Arbitration and Conciliation Act relating to a commercial dispute of a specified value pending in court shall be transferred to commercial court. Provision of this act shall apply from the stage of the proceeding is transferred. Order 5 Rule 1 subsection 1 of CPC. Time to file written statement within 30 days and not later than 90 days from the receipt of summons shall not apply to such transferred suits, the court in its discretion prescribe a new time period for filing written statement. So therefore, if in your old proceedings, the commercial object is involved, if it is not yet transferred to a commercial court, I will request every one of you, just see, even if the file is in your senior's office, tell him, inform him, because seniors are always busy. They are not aware that such type of procedure or provision is there. So tell them that even such old suits can also be now transferred to commercial courts, and therefore apply it to the registry and get the suit transferred to a commercial court. Now come to the next slide. Now see the time duration. The first 3 months mediation, pre-institution mediation, consider that that mediation failed. So after 30 days, after these 3 months, 90 days, the suit is numbered. Then comes to 120 days written statement. Then comes to 30 days of the inspection of the document. Thereafter 15 days for admission and denial of the documents. Thereafter 4 weeks from the admission and denial of the documents, the first case management hearing takes place. Thereafter, the first case management hearing would give a schedule not beyond 6 months at all. So after 6 months, completion of the oral arguments, and after completion of the oral argument, pronouncement of the judgment will come. So in a way, liberally, even if giving it a complete concession, even if considering that our courts are extremely busy, then also a Commercial Courts Act suit would be able to get disposed of within a period of 2 years to 2.5 years. Now, I'll tell you that in our city civil code, the Commercial Courts Act suits are disposed of in 3 years maximum. A contested suit which is recently disposed of, the duration is of 3 years only. So imagine a situation that a civil suit is being disposed of in 3 years is really a great achievement. So therefore, I will request all of you that we have to change the culture of our law profession. We have to adopt the practice of honesty. We have to adopt a practice of genuineness and truthfulness, not lying before the court and not misrepresenting and wasting the court's time and the client's time also. And if we work in this efficient manner, I am sure a suit will be disposed of within such prescribed time itself. And ultimately, the trust of public on our judicial system will increase in many fold. And therefore, I request you, be honest, be genuine, be truthfulness. And I am telling you, nobody can stop you in your law practice. Nobody can stop you from becoming a specialist in Commercial Courts Act. Thank you very much. I'll be happy if there are any questions in anybody's mind. Yes, sir.
Yes. Anyone having questions?
See, our senior colleague has raised a very genuine question that what happens when the court is on leave. See, friends, I am telling you, there are not hundreds, there are thousands of challenges to our system. No doubt about it. There are so many difficulties. But we as a lawyer have to see only the positive side. I know these difficulties are genuine. I accept that this is bound to happen. And therefore I told you that by granting concession, therefore I told you by granting some liberty, that on few dates courts is not available, the court is busy, the court could not conduct the work, or the court gets busy in some other matter, then also as a lawyer, it is your duty to point out to the judge that, see, the act says that this is the time limit. If the time limit of 15 days is over, that means over, that stage is over. Now come to next stage. This is what your duty is. Unless you invite attention of the judge to that particular aspect, that, sir, on last occasion you were not there, all right, but this time duration of 15 days is over. Now your honor is not empowered to grant extension unless there is some genuine reason. If there is no genuine reason coming, you please proceed to next stage. So in short, my request to you is, don't go to any negative or any aspect which will fail this particular legislation, which will make this particular legislation as any other legislation. Don't do that. I will request every one of you, please ensure, see the positivity, see the intention of legislature. Despite of having thousands of difficulties, be positive and act positively. Yes, ma'am. So see, she is saying that this pre-institution mediation is prior or after the suit also. No, you are asking about limitation of the suit. Is it so? Huh. Yes. No, no. See, you approach to the court with your plaint. So the day you approach to the court for mediation, your limitation stops. No.
Pre-mediation gets done after completion of your limitation period, rather after lapse of your limitation period, then your suit itself is not.
Then suit itself is barred by limitation. It is part of game. Yes. Okay. Anybody else? See, प्रश्न असा आहे की जर स्टेट पार्टी जर असेल अंडर सेक्शन 80 प्रमाणे नोटीस द्यावी लागेल का? Sir, I have clarified in the beginning itself. There is absolutely no change in the substantive law. The change is suggested only in the procedural aspect. So, if the substantive law requires you to give a prior notice to the government, it is necessary. Only thing is, earlier what used to happen that in tender matters, if the government is party, that means what? You require early judgment. And if you require early judgment, if you don't want to go in disputed facts, you used to approach High Court. So the object of this provision is to lessen the burden on High Court. That is the only object of this provision. So whatever substantive provision is there, it is bound to be there. Yes.
त्याच अनुषंगाने मला कंपॅरेटिव्ह स्टेट म्हणून असं विचारायचं होतं, ऑर्डर 37 मध्ये आपण जेव्हा समरी सूट दाखल करतो, समरी सूट दाखल केल्यानंतर पहिले 10 दिवसाची आपल्याला कोर्ट परवानगी देते आणि त्या 10 दिवसामध्ये आपल्याला रिटर्न स्टेटमेंटचा डिफेन्स असेलच तरच आपल्याला रिटर्न स्टेटमेंट दाखल करण्यात येतात. मग तुलनात्मक दृष्ट्या जर अभ्यास केला तर सीपीसी मध्ये ह्या कोर्टामध्ये आणि त्याच्यामध्ये नेमकं काय फरक आहे, काय फायदेशीर ठरू शकतो?
नाही, तुम्ही जर बघितलं ना तर वेबसाईटवर समरी सूट सुद्धा कमर्शियल करून चालवलेला आहे. म्हणजे तुमचं जर म्हणणं असेल की समरी सूट इज अ फास्ट ट्रॅक, तर आता मी तुम्हाला असं म्हणेल की सुपर फास्ट ट्रॅक आलंय.
हे आपण सांगितलं. दुसरं आपण जे सांगितलं की कोर्टाला जर वाटलं एखाद्याचा कंटेंट खराब असेल तर त्याप्रमाणे कोर्ट त्यामध्ये आदेश देऊ शकतो किंवा तशी ते करू शकतो. मग मला राहून प्रश्न असा वाटतो, सीआरपीसी मध्ये अशी प्रोव्हिजन आहे किंवा सीपीसी मध्ये 18-12 प्रमाणे पण प्रोव्हिजन आहे डिमेनियर ऑफ विटनेस.
येस.
बरोबर आहे.
येस.
पण डिमेनियर ऑफ विटनेस मध्ये माझ्या छोट्याशा प्रॅक्टिस मध्ये म्हणजे आतापर्यंत ते जजमेंट वाचले किंवा माझ्या वाचनात आलेले किंवा अभ्यासात आलेले कुठेही मेहरबान न्यायालय डिमेनियर ऑफ विटनेस याच्याबद्दल भाष्य करताना आढळत नाही. तर याच्यामध्ये आपल्याला कंपल्सरी आहे का, मॅन्डेटरी आहे का?
नाही, आता कसं आहे की इथंच तर लॉयरचा रोल येतो. मी जेव्हा म्हणतो ना की स्पेशलायझेशन आहे, तर आता लॉयरचं काम आहे की साहेब हे बघा आम्ही किती रिझनेबल बोनाफाईड ऑफर दिली होती, यांनी ॲक्सेप्ट केलेलं नाही आहे, हे कोर्टाच्या निदर्शनाला आणून द्या आणि त्याचा इन्क्लुजन कॉस्टमध्ये कॉस्ट मारताना हे कन्सिडर करा, हे आपल्याला सांगावं लागणार आहे. जोपर्यंत डिफेन्सचा लॉयर डिफेंडंटचा लॉयर जोपर्यंत हे पॉइंट आउट करणार नाही तोपर्यंत कोर्ट तशी ऑर्डर करणार. So therefore you have to be aware. The reason I am mentioning that you have to study this law in detail. You have to master the provisions of Commercial Court Act. याच्यासाठी सांगतो मी. खूप राईट मुद्दा निवडला सर तुम्ही.
त्याच्यामध्ये आपल्याला एन्लाइटमेंट टाइमला फक्त 2 संधी दिलेली आहे. ऑर्डर 17 पण आहे. पहा ना आपण तुम्ही व्ह्यू स्ट्रक्चर जे मला माहिती आहे. मग 148 मध्ये स्पेसिफिक प्रोव्हिजन आहे, 17 मध्ये स्पेसिफिक प्रोव्हिजन आहे. तरी कायद्याला लॉ मेकर्सला असं का करावं लागतं? म्हणजे आपण कुठेतरी सीपीसी अपयशी ठरतोय का काय?
नाही असं नाही सर. त्याला काय होतं की ते तुमच्या ज्या सगळ्या प्रोव्हिजन सांगताय याचा असा त्याला टीथ काही नव्हते किंवा तुम्ही जे नाही केलं तर काय मॅक्सिमम कॉस्ट किती 3,000 रुपये. इथं आपल्याकडे पक्षकारच येतात मोठमोठ्या गाड्यातून, त्यांना काय घेणं पडले 3,000 रुपयाचे, हे घे म्हण. आता असं आहे की आता आपल्यासोबत कोर्टाची सुद्धा तेवढीच मोठी जिम्मेदारी आहे. कोर्टाला सुद्धा त्यांचं अस्तित्व जाणवून द्यावं लागणार आहे. कोर्टाला सुद्धा आता ह्या ऍक्टमध्ये अशी प्रोव्हिजन आहे की गव्हर्नमेंटनी स्पेशल ट्रेनिंग द्यावी आणि स्पेशल ट्रेन केलेले लोकच कमर्शियल कोर्ट म्हणून बसवावे. आणि जेव्हा तुम्ही कॉस्ट करता तेव्हा या सगळ्या गोष्टी इन्क्लूड करा, मोठमोठ्या कॉस्ट लावा, तेव्हाच पार्टी आणि लॉयर डिलिजंटली काम करतील, हा उद्देश आहे. आणि म्हणून हा लेजिस्लेशन जर सक्सेसफुल करायचा असेल तर आपल्या अवेअरनेस शिवाय पर्यायच नाही साहेब.
माझं असं म्हणणं आहे की जेव्हा सेटलमेंट होते मॅटर, सेटलमेंट मॅटर झाल्यानंतर समजा पहिल्या स्टेजला मॅटर सेटल झाला तर कोर्ट फी ऍक्ट प्रमाणे 42 ते 41 मध्ये आपल्याला कोर्ट फी रिटर्न मिळते का?
हो. मी तुम्हाला सबस्टॅन्टिव्ह मध्ये कुठलाही चेंज सांगितलेला नाही.
पहिल्या स्टेजला
बिलकुल येस. See madam, other things are all same. I am just saying that it is just an expedited procedure and way of working out the suit. That's it. Yes. I am not suggesting any new change in the Evidence Act also. I am not touching that aspect. See, if you want to confront a witness during the cross-examination with some surprise document, you have to face the music under Evidence Act. There is a provision under that. other side will take immediate objection. The first day itself, you have filed an affidavit in statement of truth saying that I have no other document except whatever is filed in the plaint. So therefore, out of question, madam. You can't do that practice now. You have to stop that practice. No, see, there are such type of loans also, friendly loans. If there is no interest agreed between the parties, why are you claiming interest? So you assess on your own basis. You justify that, and let us see how it happens to the final judgment, and thereafter appeal. I am again telling you, your regular law regarding maintainability of a suit would apply to every suit. See, what just I am trying to tell you that if it is a money suit, if it is a friendly loan, but if you say that this is for some commercial purpose, only then the commercial court would get jurisdiction to that, not otherwise, not the personal transaction between two friends. Then what? If the money was given for some commercial purpose, naturally you have to claim that whatever is the National Bank's rate of interest, you give me that. No, you can't claim. All right. Yeah. Yes.
Because in that we have a summons for judgment that there is a condition, it's a discretion of a court, whether to entertain for filing of written statement or not. So in that there is a conditional order as well that is more superior than the commercial court. Then why we are transferring here when we are getting a relief under there?
No, don't do that. Don't do that.
Then is it compulsory if you are filing the summary suit under 37? Is it compulsory that they will transfer after the passage of time in this commercial court?
They are doing it. They are generally doing it. But if you are not in the way I told you that, see, this is a fast track and super fast track. Yeah. Suppose in a summary suit, if the leave is granted, and if it becomes a contested suit, then what will you do? Don't be overconfident that, see, my summary suit, it is going to be. No, I'm just trying to tell you that as a lawyer, why are you avoiding Commercial Court Act? Go to that. There are proceedings, commercial and summary suit also. If you check the
What I should prefer, whether to go to
commercial. My personal experience would be Commercial Courts Act.
Today you have given all the details in minutely. So it's so procedural part is so strict.
Yes.
It's so strict, but it's not in the summary. So technically to deal with that, I will get more this benefit in summary.
So this is the perfect lawyer's brain. All right.
But one question is that whether I should go for a summary suit or what I should prepare.
No. My request or my advice would be commercial summary suit. Yes. Thank you very much.
Assume that West, it would not be detrimental. It will be determined by the office of the honorable court, no? The moment you file and the summary presume, but due to the nature, it will be determined by the office, whether it will be something or it will be what the commercial court said. Yes.
What we emphasize is after
Of
all,
course.
if there is any ambiguity to section
As our fellow brother has pointed out, under commercial court sectors where there is a provision for summary, commercial summary is to be a jet speed.
Okay.
As of now, it is only in high court. We are yet to apply that. So, ultimately, assuming that your summary subject, you find it in the summary, and if that gets applied here, I am presuming that you would be the double judge. Yes.
When there is an ambiguity in two sections, what we supersede?
aspect you are saying. This is a basic procedure that we are dealing with. I am sure my brother has already explained. Other technical aspects, perspectives, and everything, like you are asking about evidence and applicability there, or CPC to some extent it may apply. Certainly, it is not superseding anything. No.
Okay, all right. Chalo, thank you very much. Yes. That is not mentioned in Commercial Courts Act. Our topic was Commercial Court Act procedure only. No, see. No, our learned senior's question is that.
So just a wide presumption. I will not trouble our brother to answer this. Just wide presumption may accept that application and may impose cost, better cost of that. You are right, absolutely. They may stick to the procedure laid down, and they may stick beyond procedure and therefore cost you.
No provision.
No.
No provision. Commercial Courts Act doesn't speak about pursuits.
Sir, I presume the basic list.
No, sir. What you are.
Well explained by our.
No, see. The. See, therefore, sir. Therefore, the legislature has provided all the precautions. Whatever you have to file documents or whatever steps you have to take, everything has to be done fully prepared, proper pleadings. Now don't disturb the entire trial. Yes. No. Court will accept. Absolutely accept. Court will have to accept. Chalo, thank you very much, everyone.